it would be most advantageous to know the rules of this game. Yet here we are, caught in a game we didn't even realise existed, let alone understand the rules. Now, the name of the game is Monopoly. Has anyone ever played Monopoly before? Yes. The goal is simple. Become the wealthiest player by buying up properties, collecting rent, and driving everyone else into bankruptcy. Sound familiar?
Yeah.
Because in the real world version, there are two players. Player one is the government, the police, and the judiciary all working together. And player number two is you. The politicians hold a monopoly over the Parliament. Parliament makes the rules. The police enforce the rules, and the magistrates and judges interpret them. And of course, the media monopoly, controlled by a handful of giant corporations, that shapes the narrative so you never ever question the game. Now, most of us have heard of Operation Mockingbird. Yeah, okay, most have. But if you don't, look it up. So what happens when the rules written by player one, political parties, heavily influenced and often steered by foreign corporate entities and interests, start harming player number two, which is you? What happens when the very people they were meant to serve become nothing more than obstacles to power? The answer is simple. The balance breaks. And when those in power serve themselves or outside agendas instead of the people, ordinary people become vulnerable. The rules stop protecting fairness. They become tools to lock in inequality and silence dissent. So when that happens, it's not just individuals who suffer. It's the very trust in governance and justice that crumbles. So this happened quietly, without our knowledge or consent. Like one player stealthily buying up every property, while the rest of us are still rolling to get our go. In 1972, Australia had what you call a monopoly power play. During the infamous two-man Doom-Verate government, Gough Whitlam and Lance Barnard didn't just pick up a couple of extra properties. They took all the ministerial portfolios, bypassing every normal constitutional check. In just a few months over Christmas, while the country was distracted, they rewrote over 40 Acts of Parliament. They quietly changed the constitutional definitions. Ironically, something the Constitution itself says they had no power to do. Now imagine if, in the middle of monopoly, one player decides that hotels only cost them $2, or that if you land on their square, you owe triple the rent. That's exactly what happened to our foundation constitutional safeguards. Then in 1975, under Whitlam, Australia signed the Lima Agreement. This set international goals that led Australia to slowly dismantle key local industries like our car manufacturing and white goods sectors, handing more control of our economy over to foreign interests. It's like letting outside players come in, buy up all your railroads and utilities, then charge you rent to live in your own house. By 1986, Bob Hawke's Australia Act rolled out the final big red hotel on the boardwalk. It unlawfully severed our constitutional ties to the true crown without a referendum, replacing it with the statutory fiction, the Queen of Australia. Now here's the kicker. Under international law, through treaties like the Hague Convention 1907, which has bound Australia since 1910, governments and occupying powers must respect existing laws, institutions, and the rights of the people. They are forbidden from tearing them down without cause. It's like even the official Monopoly rulebook said, Player 1 must protect Player 2's original rules, safeguards and agreements. But instead, our governments quietly rewrote the whole rulebook behind our backs, breaking not only our own constitution, but international promises meant to protect it. Now, meanwhile, in 1966, they'd already ditched our gold-backed imperial pounds, real money with tangible value, and replaced them with fiat decimal dollars, a debt-based currency that can print endless money, like monopoly money, all done without a referendum, without your consent. Then in 2003, Australia passed the Acts Amendment and Court Repeal Legal Acts, sorry, it's a tough one, this act. Acts Amendment and Repeal Court Legal Practice Act, which formally removed the Crown from every courtroom, rewriting the titles and powers of our courts under state corporate structures. Today we stand before corporate courts, run policy instead of constitutional law, still draped in the old symbols, and no one sees the swap, or no one saw the swap. Why didn't we see it? Well, this is because back in 1939, under a formal agreement called the Declaration of Teaching of History and Revision of School Textbooks in the Australian Treaty Series of 1939, Australia began embedding, now this is important, embedding international educational policies that quietly reshaped our school curricula. That was just the start. Decades later, it evolved into sweeping global educational agendas under the United Nations, pushing international narratives deeper into local classrooms. Generations grew up, never knowing it was a rigged game running against them, never taught the true constitutional principles that once secured their sovereignty. So they never thought to question why the banker always seemed to be on the other player's side, player number one. So let's bring it down to the personal. So the local board where I have stood, because this monopoly isn't just about Parliament or treaties, because this monopoly isn't about that. It continues in your local courtroom every single day. The police hand out the token, and it all starts when the police show up. They hand you a little pewter hat and say, "Congratulations, you're now a contestant in the Western Australia Justice Monopoly. Here's your infringement notice. Here's your summons. Whether you want to roll a dice or not, you are playing. No opt-out, no polite refusal." They place you on Old Kent Road, the Magistrates Court, a tired little building with squeaky doors and outdated decor. But it's the most expensive square on the board. You roll your first dice, land on, pay $500 for state administrative costs. Try to ask why, and they tell you, because that's the fee, because your paperwork was defective, because we said so. Try to defend yourself, appear as a self-represented litigant, and suddenly you're the wild card that threatens their entire rigged game. Then comes the chance cards. Your trial's adjourned for 6 months because the prosecutors forgot the witnesses. Pay Crown costs anyway. Oops, your affidavit wasn't signed in the way we wanted you to. lose your right to appeal. And if you mention the constitutional rights, common law, or the Magna Carta, the magistrate reaches for that go to jail card. I know, because I've lived it. I was removed by force, injured by court staff on the magistrate's orders for simply standing firm in my right to question jurisdiction. Now, eventually, you claw your way up to the Supreme Court, the Supreme Court Avenue. Your case becomes Kelly versus Fianda 187. Surely here, the rules will be respected. But they say, we won't entertain your evidence because your cover sheet didn't meet technical compliance. Meanwhile, the state's sloppy paperwork rolls right through. Justice is swept off the boards like crumbs after tea. Then there's Porter versus Kelly. The Department of Transport prosecuted me on shaky foundation. No valid certificate witness. I defended myself. And they expected me to cross-examine a piece of paper. Eventually I was acquitted. Victory? On paper, yes. But when it was remitted for retrial on a technical point, thing is, I did pay the thing, but it was a paper prosecution. I saw the deeper truth. The entire business model depends on uncontested prosecutions, hidden procedural traps, and endless costs. The longer they keep you playing, the more they collect. And each chamber of the Monopoly Board, from Magistrates Court to the Supreme Court to the High Court, is stacked floor to ceiling with self-serving case laws, like deeds on a shelf written by yesterday's winners to secure tomorrow's game. So when you walk in hoping justice means finding the truth, I actually did think that, not anymore. You find instead it's about applying the last judgment, even if that judgment was crafted to protect the system from scrutiny and not you. Now finally, you look up the board to Mayfair, the High Court of Australia. Polished marble, hushed chambers. Surely it ends fairly. But by the time you get there, you're bankrupted, exhausted, and your health is in tatters. Standing there with your Monopoly hat reading entry fee, your life savings, and your last ounce of hope. You know? It might sound funny, Monopoly boards, chance cards, little pewter hats, but it's no game. It's our homes, it's our health, it's our families, and it's our sanity. It's thousands of Australians forced to stand alone against prosecutors with unlimited taxpayers' funds, while the state rolls the dice with our lives. That's why I'm here today, not just to tell my story, but to demand change.
Yeah!
Yes! We need law that recognises the profound disadvantage faced by people forced to self-represent themselves. Provide real help, not glossy pamphlets or knowing smirks from registrars. Anyone experienced that before? Yes, okay. And ensure that when a self-represented individual successfully defends against a flawed or malicious prosecution, they can recover proper costs, the same as a wealthy defendant. Justice should never be at a roll of the dice. It shouldn't depend on whether you can afford the biggest lawyer. It should be a right, equally available to multinational monopolies and to the single mother defending her freedom. It should be. absolutely. But it's a rigged game, remember? I'm a member of the Self-Representing Litigants Association. Johnny Q and I have written legislation to present to Parliament to balance the playing field and to hold judiciary accountable for their actions. If you want to know more about this, just have a chat to me afterwards. So the next time someone shrugs and says, "Oh, that's the system, oh, that's how it works," I want you to think of that Monopoly board. The police handing out tokens, the magistrates collecting rent, the Crown costs bleeding you dry at every turn. Then ask yourself, who built it? Who profits from it? And why are we still playing when we never agreed to roll the dice in the first place? Now it's time we stopped playing their game and started rewriting the rules.
Yeah!
Testing. I got 5 minutes Q&A with Dawn Kelly.
Yeah!
Before we get into that though, can you see why I said Dawn Kelly is such an important woman? And I encourage you, go to her website, still dawnkelly.com.au.
It's offline at the moment. But if you're interested, it's dawnmichellekelly.gumroad.com. So some of my content's there.
And especially some of the content regarding our history, regarding the Anzacs, it's incredible. I strongly encourage you guys to find some of this work. But yeah, any questions for Dawn whilst we've got her here? Please.
Define fighting.
How long did it take you? Because I've got a couple of friends that have taken big people to court, and I've been suggesting to others it takes a 2-year process, which I think that's what you said, right?
So when you say take people to court, what do you mean?
Well, when you fight for your freedom or you fight, so they took certain departments, so we shouldn't go into it because it's not up to It took 2 years of them fighting in various courts, like you said, and at the end of the day, I think the mob that they were fighting, which is a corporation, had a $2 million bill for their lawyers, and it came out that, well, if you're guilty, you're paying out $2 million. But if you agree as a stalemate and have a gag order, we won't take this any further. So it looked like they were going to win, but they were threatened if they didn't win with a $2 million taxpayer-funded court bill. So is that the process that, or yours was more an individual?
No, well, I was defending a claim, so they alleged that I did something that it's traffic. I'm not fighting anybody. I'm just defending. It's my right to defend myself, and that's the thing. If the government, the police, or anybody makes a claim about you, it is your right to defend yourself, and that's why I'm standing for it. It's like, well, hang on, and it could be something from like a multi-nova, and you weren't speeding, but it's easier to just pay it. I stood up against something little like that, and I learned a lot. However, at the beginning I didn't know much, and now it's stay out of court. Now, Jackie, actually, can we invite Jackie? Sorry, I don't mean to take over, but she's going to. Can we talk about the thing coming up with the High Court?
I'll try my best. All right.
Please.
Yeah. You're right.
I did say powerful women. So, can we interview Jackie now?
My friends,
I'm
they're
not
just
really.
being restricted. I've already been told.
Oh no.
We will be mindful of time.
Yeah.
5 minutes on the clock.
So I'd like to, we're discussing a project, because it ties in with what you're saying in terms of defending and taking somebody to court. Can you explain about the Biodiversity Act?
as I was mentioning yesterday, we are looking for plaintiffs to take on matters. So I've even put it to Jamie McIntyre to become a plaintiff in one of her cases, because for all of these grievances that we've got to find the remedy and the solution, and the way is to take it into the courts. So we're in the middle of speaking with Dawn is considering doing our case, which is the bottom line of it is going to knock out the WHO Treaty. So this is going against the Commonwealth. So the grounds of this are that the legislative powers of both state and Commonwealth parliaments are indivisible. And you'll find at section 47 and 48 of the Biosecurity Act is where the WHO recommendations are written. Now that basically equates to treason. They cannot write in a private organisation's recommendations into our legislation. So this is the case Dawn's going to take on. Contained within this case is also going to be the challenge under the External Affairs power pertaining to treaties. Treaties can only be entered into between two or more independent nations. The World Health Organization is not an independent nation. Neither is the United Nations. So the potential of this case is to knock out the WHO Treaty, the Uni-Joint Treaty, the UN Treaty and the Lima Agreement. As unconstitutional or invalid as we can see acts are, until we take them in and actually challenge the validity and have them invalidated, they remain. So it's up to us to implement and initiate the change that we seek. So through the judiciary, through the High Court.
Thank you. And that's where I come from. I've had a lot of court experience, and so I can, know my way. I'm not an expert, but I'm a fast learner.
All right, one more question to Dawn Kelly. We're going to be mindful of everyone's time. Gentleman in front here.
Oh yes, I just wondering, when you talk about the 1930,
The 1939 treaty. Okay, so if you go on to, obviously it was ratified by particular parties, which was particular parties. If you actually go on to look up the Australian Treaty Series, it gives every single treaty. I think Darren Dixon, he's actually captured that whole information, so it made it easier to find. But look, I would suggest go and look it up. But the key thing to remember is that treaty is why we are here why nobody knows, why our children are being educated with a foreign globalist agenda. And it all started with that treaty. And it's just to where we are now. Anyway, I've taken up enough time. Thank you.
Ladies and gentlemen, please give it up for Dawn Kelly.
Yeah!
What a powerful team. Thank you, Dawn Kelly, absolutely incredible. All right, ladies and gentlemen.